Right, hello everybody, and welcome to our yearly update of the recent and inspiring cases about expert evidence. This is our 6th year of this particular topic, and as usual we are always impressed with the fact that there never seems to be material to talk about. So I have 4 recent cases to talk about today, which are all Australian cases, and then Tony's going to do the usual split where he talks about some international cases. Before I kick off with the cases, let's just have a quick reminder of why it is that expert evidence is important. In order to succeed on any claim that we bring, we often have to provide evidence that supports the particular position that we are putting. And we need to make sure that the evidence is admissible. And I'm sure we'll all remember that the Evidence Act is drafted in a series of rules to which you then need to find an exception. And the relevant section of the Evidence Act for expert evidence is 76, and the starting position is always, it is not admissible. Opinion evidence is not admissible. So in order to get around that, we've got to shoehorn ourselves into the exception, section 79. And we really need to deal with 2 issues. One is we've got to have some specialised knowledge, and that's got to be specialised knowledge that's recognised by the court as a specialised expert field, and a couple of the cases that I talk about tonight deal with whether or not a particular topic is or isn't recognised as expert evidence. And we've got to have an expert who is an expert in that field and actually has the proper relevant experience or qualifications or both. And then they have to give an opinion that is wholly and substantially based on that expertise. And every year we seem to have no trouble finding cases where those things just don't quite add up and people come a cropper. So I'll also want to just briefly talk about UCPR Schedule 7. Everybody will be familiar with the fact that there are various different codes of conduct. That's the Supreme Court one, but there are others in different jurisdictions, and experts also have to comply with those when they prepare reports. There's a couple of salient points from the UCPR Schedule 7 there. The overriding duty to assist the court impartially, and for an expert not to be an advocate for a party. I think they're 2 of the most important features of the code, and things that we really have to make sure that our experts are aware of, and a couple of those feature a bit today as well. And there are similar provisions in the practice note in the Supreme Court Gen 11, which talks about expert conclaves, and most jurisdictions have the idea that experts will meet with their counterparts and conclave and produce a joint report. And again, there are provisions in the practice note that deal with that, and experts have to be very mindful of what it is they're supposed to be doing when they go into conclaves. And again, one of my cases today touches on what happens when an expert sort of forgets about that process. Now my first case is Ali versus R, and this is a criminal matter that went to the Court of Criminal Appeal. And the applicant had been found guilty of obtaining financial advantage by deception, based in part on evidence led by the Crown about telephone intercepts. And the issue on appeal was the admissible scope of the expert evidence on the telephone calls. The Crown said there's a voice on the phone that is the defendant, and he said in the classic defence, it wasn't me. So that was the appeal on whether or not the evidence established that this was him in the calls. Now there were 24 phone calls involved, and they had been made originally in Hindi, and they had been translated into English by Amos Agarwal, who was an accredited interpreter. So there was no doubt that she had the relevant expertise to interpret the phone calls. But in her report, she went a bit further than interpreting the calls, and she purported to express the opinion that the voice in all of the 24 phone calls was the same voice. That was very relevant to whether or not the "it wasn't me" defence was going to work. So objection was taken to that evidence from her, and there were 2 issues with it. One was whether or not this was in fact an expert field at all. So is it the case that she was in a better position, for example, than the jury, to say, well, that voice is the same voice, or is that just something that anybody can form a view on? So is there an expert field at all? And the second issue was whether or not it was admissible per Section 79, because she didn't have specialised knowledge or training in the field of is a voice the same as another voice. Her expertise was translation. So the court had a look at both of these issues in relation to her evidence and rejected them both. So rejected both of the objections. The court said she's highly specialised due to her experience and familiarity with tones and pitches of language, because she's an interpreter. And also, specifically in relation to these phone calls, her evidence was that she had listened to them over a period of 15 days, the phone calls, between 3 and 7 hours a day. So if any of us are having a bad day and we think our jobs are dull, don't have to listen to the same phone calls for 7 hours a day. And they said that that familiarity with this particular subject matter gave her a greater understanding than anybody else, like the jury, just listening to this stuff for the first time. So it was accepted that she did have a particular expertise in relation to these phone calls. And the fact that she didn't have a formal qualification in that didn't matter, because they said that was the experience that was necessary to give her the expertise to form the opinion that she did. So that evidence was accepted, and both of the objections were not. Now the next case, Anderson and Canaccord, is this one that talks about the code of conduct that I referred to earlier. And the court made some quite serious observations about the conclave process in the practice note and what it is that the court expects of experts when it's engaging in the conclave process. Now, the underlying dispute in this case was a claim for damages on the basis that various different defendants, and there were many of them, had wrongfully caused the destruction of a business, and the business was property acquisition, development and funds management. And there's a lot of expert evidence about valuation of the plaintiff's loss, and it included things like loss of opportunity, loss of revenue and future fees. And the plaintiff relied on several expert reports of a Mr. Halligan, who had been instructed on the basis of various different assumptions to determine the market value of the plaintiff's assets that had been apparently destroyed by the defendants. Now, there were two significant complaints made about Mr. Halligan's expert evidence. First of all, he was criticised for not forming his own view on particular matters. So this is the conclave process. And it appeared that he had engaged in conclaves, as he'd been ordered to do, in order to produce a joint report with his counterpart, Mr. Hall. But the joint report just contained big chunks of sections where Mr. Halligan had essentially said, I'm not going to engage on those issues because that's my instruction. And Chief Justice Ward had quite a lot to say about that, and she said, well, there are very clear obligations in the Expert Witness Code of Conduct, and of course this is the Supreme Court, so she was talking about Schedule 7 and the Practice Note Gen 11, which I referred to. And she said, this code is not merely aspirational. She observed that for an expert to simply refuse to engage in debate makes a mockery of the expert witness process, and noted that Mr. Halligan had simply refused to express his views on any particular issues beyond simply parroting his instructed assumptions. Now, ultimately, she did not disallow his evidence on that basis. She did disallow it on a different basis, and I wonder if that's why she didn't need to go so far as to disallow it on this basis. But it's quite a critical piece of the judgment, and she's very clear in the criticism that she makes of Mr. Halligan. But I think not all judges necessarily have the same approach to that. I had a similar issue in a case last year where on my side of the bar table we were very critical of the expert on the other side, who we said didn't engage with particular things in the joint conclave, and we had a joint expert report where it was very clear that the expert had said, you know, I haven't looked at this, I'm not looking at it, and so on. And we complained uphill and down dale and cited this judgment in favour of why the judge should be very cross about that. And he wasn't very cross about that. So, you know, it might be that different judicial officers have different views, but I still think have this in mind when you're instructing experts, and I find it's a good idea to test experts when I speak to them about whether or not they, my party's experts, but whether or not they have looked at the code of conduct and they have complied with the obligations. I know they all say they do. Every report says, I've read the code, I abide by the code, I'm familiar with the code, etc. But have they? And if you ask them, you might easily get a question that reveals that they haven't actually read the code at all. So I think there's some lessons to be taken from this.
Surely, when you're dealing with a novice expert, because this is something that comes up in the UK cases that I'm dealing with tonight, when you're dealing with a novice expert who wants to assist, is well qualified, is clearly clever, but is new in the game, to what extent do you, I mean, I'll say what I do in a second, how do you handle that expert when they're going into their first conclave? To what extent do you brief them about exactly what they need to do?
Quite a lot. I take them through the practice note and the code, and most of them have never seen the practice note. Most solicitors will give them the code and forget the practice note or say nothing about it. So I think it's important to draw their attention to that and try to make clear that they're there to assist the court obviously first, but they're also there to assist you, and if they don't engage in the process, that will not assist you. And try to put it very neutrally, because of course they need to be free to express their independent views, but try to talk through what the consequences will be, because that's usually the bit that they don't understand. They don't understand that their evidence might fall over or be inadmissible or just be unhelpful generally if they don't follow the right steps. So do you do something similar? Or
I do something similar. I try to tell them a fair bit about the other expert that they're up against, and my observations of how it is that expert has behaved in conclaves. Construction being a small game, everyone sees the same people over and over again. I try and give them a bit of background about how that expert tends to behave in conclave. I sometimes show them, obviously with identifiers marked off, some precedents of what joint reports look like.
Oh yeah, and I've done that. I think you can draft a skeleton joint report. I also tell all of my experts, which is going to be useless from now on, now that I'm making it public, that they should be the one who types the report, not the other guy or the other girl. So, because I think that is helpful.
That's a fantastic piece of advice, because them who controls the keyboard controls the flow.
He holds the pen, makes the rules. Yeah. So, no matter what I say, I have mixed results.
What do you do when they get outgunned? When they're hopelessly out? When it's clear that they're hopelessly outgunned?
Settle. What do you do?
So, so
there you go. Good to know. It's a challenge. The second criticism of Mr. Halligan's evidence was totally different basis, which was that simply all of the assumptions that he'd been given and the factual assumptions he'd made when he gave the opinion were just not made out. And of course that's the classic other thing, the trap that we can all easily fall into. And the judge went through all of the different assumptions that he'd been given and went through all of the lay evidence to see whether or not they'd been made out, and I think 90% of whatever he'd relied on just wasn't made good. So, that's the absolute, your whole case falls over if you can't make good all the facts that it is that you've given to your expert to rely on to form their opinion. So, rookie error there, and it was that error that made the judge say, right, none of this is in. So the whole of his evidence was out because the assumptions didn't work. Now my next case is Mount Pleasant Stud Farm, and this is one of two cases that I'm going to talk about which involve animals and inspired tonight's talk, Welcome to the Jungle. Now it involves horses, and if those of you who are paying attention will note that one doesn't usually find a horse in the jungle, but let's not worry about that level of detail. Now Mount Pleasant involved a claim brought in negligence by a horse trainer against his employer after he was injured when he was trying to break in a horse. Obviously, I work in construction, and I try and pick cases that are totally not construction related because they're always more memorable and, frankly, more interesting. The relevant act of negligence was failing to provide the horse trainer with an assistant capable of controlling the horse. Now, the assistant, there was an assistant who had been there, but apparently she was, in essence, too small. This girl, she was too slight a build to have been capable of controlling the relevant horse. And the trainer relied on an expert report of a guy called Mr. Gary Matthews, and it included an opinion from him on the physiology of the horse's brain and comments about the horse's DNA. Now, it was accepted that he wasn't a vet, he wasn't any kind of medical science person that would allow him to give an opinion on those matters generally. And it was asserted then, because therefore it wasn't admissible pursuant to the Section 79 exception, because he didn't have the relevant knowledge, and also a lot of his opinions were just lacking in reasoning, so you couldn't tell whether or not he had the specialist knowledge or how he'd applied that knowledge to form his views. So some of the objected to evidence involved him giving an opinion that an assistant helping somebody break in a horse, who was a person of a smaller stature, would not be able to impose his or her reasoning on the horse because horse's DNA would tell it not to trust a smaller animal. And the court found that his reference to DNA of horses when he made that kind of comment was not in fact DNA in a technical medical sense, but really just sort of, the vibe of the horse. And it was to be understood that he was talking about the behaviour of a horse, not its medical or genetic makeup. And similarly, where he said something like horses have mammalian brain, a reptilian brain, and a practically non-existent frontal lobe, again, that was to be understood as him not commenting on the actual brain structure of a horse, but generally how a horse behaves. And it was just sort of an eccentric way of expressing his view about the behaviour of horses, which he was qualified to talk about because he was a very experienced horse person. Now, objection was also taken to his views about the assistant, the assistant who was not big enough to help. He had said that the assistant was not of a suitable size, experience, height, stature and strength, and that when a horse becomes stressed, a larger, stronger and more imposing handler can use his strength to subdue the animal. Now, the defendant said, well, how tall does the assistant need to be? How strong does the assistant need to be? How do you know which is sufficient to be enough to deal with this horse? And the court said, we're not going to be concerned about those kind of hypothetical questions because that's a sort of line drawing that is not necessary here. What is necessary for him is to have given evidence that the larger and stronger a person, the more likely it was that they were able to control a horse. And that's what he'd done. So it was accepted he did have the necessary expertise and his opinion was enough and it was admitted. So a bit of a strange one. I'm not sure that we will have that same issue in many cases, but nevertheless interesting. Now, my final slide today is also about animals also not found in the jungle, pigs. And the catchwords in the report of this case, which will tell you everything you need to know, are the following: evidence, murder trial, missing body, opinion evidence about the capacity of pigs to devour a human cadaver without a trace. So you now have the gist of what this case is about. Now, Mr. Bowie was arrested and charged with the murder of his wife, who had disappeared in 1982. And the evidence against him was entirely circumstantial, that is, there was no body. But the case theory was that he had disposed of his wife's body by feeding her to pigs. He had a piggery, and he had apparently made comments to various people over the years that pigs don't leave any evidence. It's quite a grim case, really. Now, the Crown sought to adduce an expert report from a Sergeant Lauren Atwood as expert evidence, and objection was taken to it on the basis that it did not fall within the specialised exception in Section 79. Now, her report was titled "A Casework Study, the Effect of the Porcine Digestive Process on Animal Carcasses and Human Teeth," and it documented an experiment, note, one experiment, single experiment, carried out by Sergeant Atwood with the aim of working out whether pigs would consume a human body, including bones and teeth, and whether anything would be left behind. Now, the experiment was in fact carried out using kangaroo and porcine carcasses rather than human flesh. A bit disappointing, maybe, but it did include human teeth. And the conclusion that she proffered at the end of this experiment was that some human teeth do survive being eaten by pigs. Now, the court found that there were quite a few issues with this evidence. First, there was no evidence to establish that using kangaroos and pigs, which she did, was an appropriate substitute for human flesh. How do you know if they are just the same? And I think we'll all be comforted to know that this means that we are not pigs or kangaroos. I'm very happy about that. And the evidence, because it couldn't be established that they would say, was actually rejected as not relevant under Section 55 of the Evidence Act. So that was the first problem with it. Not our Section 79 exception, but in any event, not relevant because it wasn't dealing with humans. The second problem with it was, pursuant to Section 79, that there was no area of specialised knowledge. So there's this same idea of whether or not there's even a field here of expert evidence. And that is the expert being whether or not pigs eat humans. And the Crown said, well, this report is pioneering. It's the first report of this kind, and okay, there might not be any evidence about this now, or before now, but there is now, because this is it. This is the expert field. We've done this experiment. It's a pretty bold submission, given that it was the one experiment. But they said, well, she's got experience in conducting experiments in general. She's an experienced scientist. And that's enough to establish that this experiment she's done means that she has specialised knowledge in this area. Now, the court, perhaps unsurprisingly, was not terribly moved by that idea and said, well, it's not the case that an opinion becomes specialised simply because the person who's giving it has some training or experience in some kind of area, or that area indeed. And the hypothetical question posed by the court was, does that mean the opinion of an astrologer becomes an expert matter that could be admissible in court simply because they've got years of experience of the impact of stars and planets on a person's behaviour? There was no actual conclusion expressed to that hypothetical, but I think we can all assume that the answer is no, that is not an expert field. And so Her Honour said on the same basis that determining admissibility under Section 79, whether or not this is an expert field, should involve a rigorous assessment of the scope and limits of the asserted specialised knowledge. In this case, she said the Crown had failed to identify any such area, and so the whole report was out. And with that, I'll hand over to Tony.
The starting point for the usual excursion across into the UK authorities, or Canadian, sometimes it's Canadian, but today it's UK, is a gentle reminder of the overarching obligation. The overarching obligation is expressed in many different ways, but look, just, cheap and efficient is as good as any. That's some use efficacious, but the reality is that lying at the heart of the way in which the courts approach expert evidence is that overarching obligation, and we are seeing more and more of it in our daily practices, that the courts are querying whether the way in which we are handling experts, the way in which experts are handling their roles, is in accordance with basically the efficient disposition of the matter and the identification of the key issues in dispute. The UK has been heading in sharper and sharper directions on expert evidence over the last 3 years in particular. The Supreme Court has been emboldened to impose some fairly incredible sanctions against experts, and we're not seeing quite the same thing here yet, but it's coming. We're following. Where I focus today is on an absolutely fascinating case called Chronospan. which is a decision of a senior registrar in the Queen's Bench Division of the UK. But perhaps the starting point is to go back a couple of steps. There are two cases. I'm just going to take my slides out of order for a second. There are two cases, one in 2021, Dana and Freudenberg, and one in 2018, BDW Trading, that I've spoken about previously. What the courts are looking at now is areas where it's the interface between the expert and solicitor and the interface between expert and client, and they're looking at what was going through the expert's mind at the time. So Dana is an example where the conduct of the three technical experts was, in the words of the summary, so serious as to justify the refusal of the court to allow the defendant to rely on its tech experts. And this was a very large piece of litigation. This was very expensive technical experts reports. And what we had was three technical experts who went on trips to inspect the site that was the subject of the litigation, multi-sites actually, without putting the other side on notice of what they were doing. That was sin number one. And it was demonstrated after the fact and due to some concessions in cross-examination that that was as they planned. They planned to do that without putting the other side on notice. So that was the first sin. The second sin was the way in which they dealt with the technical representatives of the client. There was one immortal line where the expert sent the client a report that says, is this the type of report you're looking for, quote unquote. Sounds all very banal, but it's a classic example of an expert going thunderingly over the line and completely losing sight of what it is that they are there to do, which is in the expert preparation stage. And again, these cases deal with different parts of the process. In the expert report preparation stage, you've still got to be mindful. You've still got to be mindful not to overstep your boundaries. Interactions between solicitors and experts in the preparation of their reports, and interactions between barristers and experts in the preparations of their reports, and interactions between witnesses and experts in the preparation of their reports. There is very little authority on what is appropriate. There is a great deal of authority on what is not. And I'm just dealing here with preparation. I'm going to come to conclaves, as Julie did before, and then it all ends in the disaster of a joint expert conference that went completely wrong. In so many ways, it's breathtaking. But it's nonetheless instructive to us. It's not just a children's horror story that's fun to talk about. It's actually got practical lessons for the way that we do our practices. But let's start with the basics, which is how should one deal with an expert in one's day-to-day practice when you have to brief them up. The approach that I tend to take with technical experts is, the first thing I say to them is, if you are asked questions about whether you had conversations with counsel, the answer in cross-examination, the answer is yes. The answer is yes, indeed, I did. Never, ever hide the fact that you've talked to your expert. Is it permissible to explain to the expert what their role is in a great deal of detail? Absolutely. Is it permissible to explain to them what your client's case is? Absolutely it is. Is it permissible to ask them what their opinion about issue X is? Yes. Is it permissible to say to them, if fact Y was different, how would that change your opinion, if at all? That's also highly relevant, because when you're in the report preparation stage, you inevitably end up making assumptions. A pile of assumptions, they're always stated in the brief, and those assumptions are sometimes based upon your understanding of the lay evidence of the kind. So I never shy away from asking the expert, if, for example, if I've got two witnesses saying different things about critical fact X, I won't hesitate to ask the expert during the preparation phase, right, this is the assumption you've been asked to make. But if the assumption was different, what would you say? What I don't do is, once they have delivered a draft report, I will go through it with a fine-tooth comb. I will assume that any comments that I make about it will become known to the other side at some point in time. I assume that every comment my solicitors make will become known to the other side at some point in time, and vice versa. I don't shy away from assisting an expert to prepare a better draft the second time, because this is where the overarching obligation works in our favour. We are all charged with the same objective, which is to deliver evidence and put evidence before the court that will assist the just, efficacious and timely disposition of the dispute. And if an expert's report is absolutely unreadable, it is doing nothing of that sort. But what I shy away from is directly challenging their opinion. So I may ask them questions about it, and sometimes I'm looking at it and thinking, God almighty, that is not what I wanted to see. But when I do see a report that has that God almighty moment in it, and we've all had them, sometimes I think to myself, should I be briefing another expert right about now? Question number one, is the expert wrong? Is always the first question. Is the expert getting this wrong? Are they fundamentally mistaken? If the answer to that is, God, maybe not, then it's time to, as Julie said, start thinking about settlement. If the answer is, I do believe they're getting it fundamentally wrong, then my personal practice is to ask them how it is that they reach that conclusion, and to explore with them their thinking process and their methodology. But the one thing I never ever say to them, either directly or indirectly, obliquely or otherwise, is, you're wrong. Simply because, for reasons that will become obvious later in this part of today's talk, it's crossing a line. Julie, do you handle matters the same way?
Yeah, and I find that mostly it's not so much the opinion that worries me, it's the drafting. And I can't work out what her opinion is because I can't understand the report. And particularly where you've got experts who are really clever, really good at what they do, know all about whatever it is that they're opining on, but they're just right at the level that they're surrounded by very clever peers who also know what they're. And you have to constantly pull them back and say, look, nobody else in the room knows what you're talking about. You need to dumb this right down. And that's the conversation I find myself having. Yes. More than anything else, please make it simple. Please make it simple.
A trick that I sometimes use is I ask them to write a summary paragraph for the start. Yeah. And often as not, once they've written the summary paragraph, you've then got a neat version of their opinion out there. And I find it then very easy to say, right, now go back and review the 8 pages that you've written beneath it.
Do they match the summary, for example?
Do they match the summary? And that's entirely permissible.
Yeah.
And you're absolutely right. That is in our practices one of the key things. They write it themselves. One difficulty that you may come across from time to time is the expert who really has trouble writing, where they're not a writer, and the natural temptation is for your solicitor, an instructing solicitor, probably someone who's been in the profession for about 5 years and is bright-eyed and bushy-tailed, to sit there and help them. It's not really able to be done. The lines get crossed. I've overseen exactly that mistake in a large piece of litigation a number of years ago, and it's not a mistake that I'll ever make again, because at a certain point in time, having a chat to the junior, she started speaking about her own views on the merits of the evidence and her own views about the cause of the facade delamination. And at that point, I then had to say to her, right, to what extent is what you've just said then reflected in the report? Oh, well, paragraph 9 I wrote myself, and it was brilliant. But the problem was, it was hers. And she said, but he agreed with it. He agrees with it. And the answer is, yeah, And the irony is, she'd done nothing wrong. The ultimate fault lay with equally with me and with the partner who was supervising. We should have briefed her properly. But the big learning that I got from that one was, if the expert can't write, time for a different expert. Just simply not salvageable. Back to Dana. Examples of absolutely egregious expert conduct. Heading off to site inspections without telling the other side. Concealing materials upon which you have relied. Deliberately not citing materials, including academic publications that you've relied upon. Conspiring with 2 other experts to do the same thing. And falling under the thrall of your client's brilliant, absolutely brilliant in-house technical advisor, who was clearly so much better than any of the experts that all 3 experts fell into the trap of deferring to everything she said. And again, she was doing it in good faith. What she didn't know was that's not what you're allowed to do. You can't lead your experts like that. And it all came out in the middle of the trial, critical point. It all came out in the middle of the trial, nothing could be done about it, and the consequence was that this fell into the category of so egregious that nothing could be done to cure it, and the party was not allowed to rely on its expert evidence at all. Now that is at the absolute top end of the scale. B2W trading is, it's quite an interesting one, because it's the classic example of the well-meaning but naive expert who attends a joint experts conclave, meets in joint session as directed by the court to identify areas of agreement and disagreement, and then makes the horrible rookie error of coming out on day one and emailing the draft report to the Solis and saying, how am I doing? Now, fortunately, in that case, the court took the view that although the conduct was of a type that was at the upper end of egregious under the rules, firstly and critically, everyone was essentially satisfied that nothing the solicitors came back with caused the expert to change their views or caused the expert to change what they wrote in that, what they put into that joint report, or indeed even cause them to change their approach. The solicitors didn't receive it and look at it like the giant rattlesnake that it was and push it away, but they were clever enough not to engage with it fully. And again, classic example of non-specialist solis who were trying to do their best by their client and didn't realise the trap that they'd fallen into. And it was a good example of where a well-mannered court looks at it with a certain amount of common sense and humanity and says, look, mistakes were made here, but at the end of the day, this is a classic example of a pretty high-end good faith mistake. It's a learning experience for everyone. You know, the cost of the application to get rid of the expert's report, of course, had to be met by that party. But it's at the other end of the spectrum. So here in Dana, we have absolutely egregious. You just don't see it. In BDW, we have the newbie expert who kind of is a bit neurotic and doesn't quite know what they're doing. And then we get to last year's Blockbuster. In the 6 years that we've been doing this, this is probably the second most instructive case that I've come across, because this one really does. When I was preparing this prezzo, I thought, God, there's something I'm doing that I have to change. If Australian law and Australian judges read this, which they will have, then there's something that I now need to back off on. We'll come to that in a second. Here we have, it's sort of a train wreck. It's sort of a train wreck, but nonetheless, again, a very instructive train wreck. We have a class action. A class action involving 157 members of a village in Wrexham in the UK, who have claimed to have been affected terribly by wood, dust and pollution of multiple kinds, including noise pollution coming from a local wood chipping factory. So dust is the key issue in this case. And there's two key dust issues. There's dust dispersion and then dust analysis. How does the dust disperse from the wood chipping plant? Where does it go? And then second issue, what are the propensities of that dust? We have the well-meaning plaintiff law firm with quite an experienced managing partner running the litigation, partner who really should have known better. We've got counsel who the judgment doesn't indicate whether counsel were aware of what was going on, but if they were, I suspect they would have been mentioned. So we're just going to assume, for a minute that this is a classic case of a middle ground approach where everyone has gotten it wrong. What's the context? The context is a joint experts. There was problems all the way from the start of the litigation in getting the parties on both sides to grapple with the expert issues. The court, to resolve the matter, had to have expert evidence on dust distribution and had to have expert evidence on dust analysis. And it was one of those cases where when you read the early interlocks, the court is insisting on it. The parties didn't seem to be grasping it because the plaintiff law firm obviously wanted to run the litigation as quickly as it could to get to a settlement, and the other side wanted to do exactly the opposite. So the court, through a very talented registrar, essentially imposed on the parties a regime for the production of expert evidence that would actually assist it. And the first mistake that the plaintiff made was making Nigel Gibson the expert both on dust distribution and dust analysis. Disastrous mistake, as it turned out. Gibson was briefed in 2017. This case is 2022. And again, let's remember we're dealing with 157 people from a very small town in Nowheresville in England, who are, under the terms of their retainer with their solis, they don't pay. It's no win, no fee, with the exception of expert evidence. And so this is coming out of consolidated revenues of the villages. What our hero does when he's briefed is our hero struggles with the difference between being briefed and preparing a report and liaising with your solicitors and counsel in the preparation of your report, and what happens when you move into the all-important, you're in the room with your opposing expert. What do you do then? Did not understand at all the difference, and it's a catastrophic difference between the two. So what we have here is an application, you can guess what the ending is already, for an order preventing the plaintiffs from relying on Gibson's evidence at all. Evidence that cost, both sides stipulated, cost £250,000, which the plaintiffs really didn't have, and had taken a cumulative total of 5 years and laid the linchpin of this entire class action. So again, every nightmare scenario here, you've got underprivileged plaintiffs who are already suffering badly and they've relied on an expert who has gone off the rails. Rather than a giant facts dispute about what the expert had done, sensibly, counsel for the plaintiff, when the inevitable application surfaced, why did it surface? Because the expert accidentally blind copied the other side in one of his emails. That's how it all came out, through an accidental BCC. The stipulation, and you very rarely see these, is it was stipulated that it was inappropriate for the claimant's solicitors to have provided comments solely to Dr. Gibson, and that Dr. Gibson should not have responded to those comments. This is all in the context of joint expert meetings between the joint experts, joint conferences.
It was wrong for an expert to solicit input from their instructing solicitors during the process of drawing up a joint statement, just as it's wrong for those solicitors to provide that input. This gets less dry in a minute when I start giving you some examples of exactly what he wrote. There was a serious transgression of the rules by the plaintiffs by reference to the terminology in the case of BDW that we've looked at before, and the court has power to revoke permission to rely on an expert. So this is the concession that starts it all, and this is a penalty hearing. This hearing is all about what do we do? The plaintiff says, look, we acknowledge that Gibson has messed up horribly, but the reality is that it's all out in the open now. You know everything that Gibson has done. You've seen the full array of what Gibson and the instructing solicitor have said to each other, and you can cross-examine on that respondent, and you know the evidence will be given the weight that it deserves. Not a bad desperation tactic as far as submissions go. Not bad. It didn't work, but that was the reason why there was the application. The application was saying, look, because it's a class action, because we're dealing with horribly underprivileged plaintiff class, because this will devastate their case, cost them $250,000, in addition to the $250,000 they're going to have to pay for the next expert. The reality is that on the balance of convenience, the balance here favours a little bit of mercy and allowing this expert to continue. Okay. The solicitor played a starring role in this case. So if this expert had just been trying to do his worst himself, he might have lived to survive another day. But the partner of the firm that he was dealing with, unfortunately, responded to his entreaties to assist him with the joint expert report. And the court gave the court in its judgment gave a number of examples, some of which are better than others. This is probably the highlight. Presumably this document will be updated again following your discussion today with the other expert. So I haven't considered comments at length, save to note the following. Need to address the other expert's statement that there is no correspondence between location of complainant and claimant 2. 2, dust criteria threshold section. Is this missing the point that the relevant data is also out of date? Air quality is improved then. 3, need to respond to what he says in the dust monitoring section. Now, this is about as good an example as you would ever want of a well-meaning lawyer critiquing a joint report as if they were critiquing a draft expert's report. It's getting the separation wrong in their minds. Again, I think that this email, if it had been critiquing his draft report, look, it's not how I would have done it. It's far from how I would regard the competent lawyer. I'd say it's outside of the range of the competent litigator, but it would not cause a report to in any way, shape or form be turfed out. It would just be regarded as being, frankly, a bit naive. But in the context of a joint experts report, this is a vintage example of simply what you cannot do. Now, of course, he started the ball rolling. He was the one who went into the experts report, who went into the joint session, and at the end of day one, emailed out saying, effectively, please help me. And indeed, in response to that, help was given. But this is not going to something like a typo. If this had been correcting typos, it would have survived. And in fact, there is not a blanket rule, and this is a very tight nuance. There is no blanket rule that a joint expert's statement or joint expert's report cannot be provided to a solicitor. But it should only be done in a very limited set of circumstances where there is a concern that the expert, one of the experts, is making either a mistake of fact or a mistake of law, a fundamental mistake of fact or a fundamental mistake of law. And if that happens, it has to be done in the open. It's one of those times where the other side needs to be brought in to the loop, and they need to be told that communication has been received from our expert, Mr. Thomas. Mr. Thomas believes that there is an instruction that should be given to clarify either A, a fact, or B, the law. We should do it jointly. And that way, and the courts, in this judgment, the court's been quite clear about it. If it is done in that way and it is done out in the open, then it is permissible. But anything that involves any kind of comment about the way in which the expert should be behaving in that joint forum, what the expert should say, or God help us, directing the expert to deficiencies in the other expert's approach is way out of bounds. Then we have Dr. Gibson himself. And again, I'm just quoting from the judgment here. In my judgment, the primary concern is that Gibson's approach suggests that he regards himself as an advocate for the plaintiffs, rather than an independent expert whose primary obligation is to the court. This is demonstrated by the following, and this is where it all started to go wrong. Gibson, having sent the first draft of the joint statement to the plaintiff's solicitors unsolicited, which could only be because he sought their views, he sent further drafts to them where he sought their input. He went out of his way in his emails to ask very specific technical questions. Two, his view that it was appropriate to attempt to include in the joint statement an evidence note that he'd prepared for a conference with counsel. This was clearly inappropriate and hadn't been discussed with the other expert. Classic example of an expert who is going out of their way to act as an advocate. Gibson providing information to his solicitors about joint discussions without at any time informing the corresponding evidence of this. If he'd done that simple step, if he'd let his corresponding expert knowing that he was asking his own people for some clarity on a matter of fact or a matter of law, then again, this decision would not have happened in the way that it did, because it would have given the other expert the ability to immediately send an email or ring his people or her people and say, this is what I've just been told, what do you want to do about it? In other words, it could have been stopped. The chain could have been stopped right there. It is always worth, and this is where I will now, from now on, when I'm dealing with experts who are getting ready for joint sessions, I will always say to them that if there is a matter that you feel that you need to discuss with your legal team, before you do anything, tell the other expert you're going to do it. And I would also indicate, probably more clearly than I have to date, really the only matters about which the expert could try to communicate with their own team, which is, again, really to clarify a fundamental misunderstanding or perceived misunderstanding of factual law or a need for an extra instruction. And I would always say, after you have told the other expert, if the other expert says, I don't agree with that, then at that point in time, you would be asking them to speak to their own lawyers. It at least keeps it out. You avoid that fatal, what turned out to be an absolutely fatal comment, with failing to inform Dr. Datson of it. Gibson's comments to the claimant's solicitors, which make it clear he was looking for ways in which he could support the claimant's case. Again, this expert wanted his clients to win, and that's never a good sign. That's never a good sign to begin with.
Can I ask a question? I assume this was his first go, was it?
Not first go, but first go in a major piece of highly contested litigation. First go in the big leagues.
Yeah.
So yes, that's actually a terrific question. I always ask, as we all do, we always ask our experts, so been an expert witness before? Oh yes I have. If the answer is, the next question is, where? Now, often as not, I want to be very clear here, I actually like
I won't preface it. I like NCAT. And experts, and I think it's actually somewhat maligned. An expert who appears in NCAT and does most of their work in NCAT is going to take a different approach to expert evidence than one who has appeared in the courts of superior jurisdiction. So, question number one is, you've been an expert before? Or yes, I have. Tell me where and in what context. Find out how experienced your expert
Google
is.
See what the NCAT or whoever found about your
That's and actually Julie's made a fantastic. One of the things that we all do is we all Google. The first thing we do is, in about a week from now, we'll all be using ChatGPT instead. But for today, we're using Google to always Google the other side's experts to find out, preferably, adverse findings that have been made against them. That's always absolute solid. That's always absolute solid gold. This is where it ended up. I've concluded the serious transgressions by the claimant's solicitors and Gibson are such that we're all looping back to this overarching obligation here. The court has no confidence in Gibson's ability to act in accordance with his obligations as an expert. The basis upon which the claimants received permission to rely on him as an expert has been undermined. Accordingly, I consider it appropriate and not disproportionate to revoke the claimant's permission to rely on his evidence. I consider it must follow that permission to rely on Gibson as a dust modelling expert is also revoked. And that's where the second shoe fell, because his conduct was only in one capacity, but because he'd been briefed in both, it took him down on both. Now, my suspicion is this case will go on appeal. I wasn't able to find any reference to the filing of it, but that's quite hard to do unless you've got access to the UK services. My tip is this case will go on appeal simply because the stakes are so high. I would be very surprised if it is overturned, simply because this expert, when they were actually being in the submissions that were made at this hearing, the expert tried to downplay and was a little bit cute about some of their conduct. So too was the instructing solicitor, who played a starring role in it all. She filed an affidavit in support of her client, and she expressed a view without any support that nothing she had done had caused the expert to change his opinion. And the court seized on that and said, look, this has no supporting basis, and this looks like you're trying, in circumstances where you've already stipulated that it was inappropriate, grossly inappropriate, this looks like you actually don't appreciate the seriousness of your own actions. So what the court was left with was, and what the court has very cleverly done, is it's made essentially an adverse finding against a solicitor based upon their conduct in the course of the preparation of the mitigation materials, which falls into the usual rule that when inevitably you mess up, and we all do, only happens once or twice a career, but when you do, that's the moment where you get to save yourself if you just put everything out there and let the facts speak for themselves. But she didn't. So she's got effectively an adverse finding against her based upon her approach to the mitigation hearing, and so does the expert. And what that does is, that's going to give the appellate courts the ability to say it was those findings that really support the basis that he lacks the ability to act in accordance with his obligations as an expert witness. The court also helpfully talked about, the no doubt inevitable impending action by the plaintiffs against their solicitors, which is always great to read if you're a lawyer. But at the end of the day, the court held that, because that was a last gasp argument that the other side put up, the clients can always sue their own solicitors. And what the court has done here is to say, look, we understand that this is going to have
profound implications on the clients and profound implications on their case, and it's through no fault of their own. But we have to uphold the sanctity of the expert evidence process. And again, so my main takeout from this decision is that I will now treat experts who are going into a joint session effectively as I treat witnesses who are under examination, which I haven't previously. It will be you run into them in the lift, you say goodnight to them when you leave the courtroom, but I will be leaving them to it. And I'll be saying to my solicitors, do the same. Just don't go near them. And I'll tell the expert as well, if this is a regular conclave where nothing happens that you feel you need to tell me about, because in the past, I haven't minded finding out from an expert how things are going. You sit there and you shut up and you listen and you don't say anything. But I think that practice that until I started preparing for this CLE I've been doing, I think it's time for that to come to an end, because it's quite clear out of the UK that there's danger ahead. We are right on the hour, slightly over. Are there any questions?
I just have one question. You said one of the mortal sins is that they attended an inspection without letting the other party know.
Yeah.
In what context? I don't understand.
It was in a context where the court had made effectively a joint evidence. It was where the court had made orders that the experts cooperate with each other, and that both experts be given the ability to inspect the site, and without putting the other side on notice that they were doing it. They'd gone out and had a site inspection. Every piece of the construction litigation you've been involved in, there's always the day when both parties go off and look at the site. In this particular case, they basically ran a ruse that they were going to do it all the paperwork and then went out to the site. So again, Dana is an outlier for a reason, because we're dealing with, frankly, experts who are conspiring. But that's the context. It was an unusual context. Everything about Dana is, and that's the reason I haven't focused on it, because Dana is just such an outlier that it's of very little instructive value. The reality is we won't come across a case like that in our careers. But this one here, we've seen things that head in that direction. Thank you. Any other questions? So please.
Chairing an expert conclave where you've got multi-party defendants, for example, and therefore sometimes multiple experts on a particular point, plaintiff has one. What are your thoughts around that, where there's such an imbalance? You've got 3 ganging up against 1, 4 or 5 sometimes. Sometimes that's sorted out, obviously, at the direction stage, and there's a rationalisation of experts, but sometimes there isn't. How do you deal with that?
You first, I'm going to.
Okay, well, what I've seen happen in recent years in that kind of scenario, or where there's just so many experts, it's like herding cats, is you get a facilitator whose job it is to sit in the room with the experts, and essentially the facilitator usually holds the pen and writes the report and says, okay, A, what do you say about this? And controls the process so that in your example, the plaintiff's expert wouldn't get overwhelmed by all these, table-thumping defendants, because they'd all just get a go to say the thing, and the facilitator would make sure that it didn't get out of control and put it down. So it can become a bit expensive, because obviously you've got to pay for the time for the facilitator. But I've seen that happen quite a lot, and if you get a good one, it's really effective, and you end up with a product that is proper and really properly sets out people's opinion in a good way, and also a good facilitator who's experienced in whatever your area is can make sure they actually answer the relevant questions as well, and don't just go off on a frolic, which they do whether or not they're ganged up on. So that's the way I've seen that dealt with.
And I have nothing to add to that other than the obvious, which is staying away from, even when an expert is horribly outnumbered, the key thing is to stay away at all times as a facilitator from any discussion, obviously, of the matter at hand. The techniques that they can use, that's entirely fair game. But it's it is the golden rule is don't touch the subject matter.
Can I ask one question?
Go for it.
Let's say in a construction matter you said you're sending out John Smith to do an inspection, and you have to give notice of that, but the other side realises you haven't produced a report from John Smith. Now that's probably because John Smith didn't give you a good report. Can you subpoena that report? Can the other side subpoena your report?
So in this hypothetical, does Smith ever see the light of the courtroom?
Smith never appears, do they?
No. But we all know that he attended and inspected, and we don't know whether a report or not was provided, and I know it might create some issues about fishing expedition, but you know that he's inspected for that party, hasn't produced anything, they're not relying on him. Question why? It only could mean either they got a better expert or weren't happy with his report.
I've had exactly that circumstance, like just exactly that, staggeringly exactly that circumstance. I formed the view that it wouldn't be subpoenaed, and that was the way that it played. That was the way that it played out. Julie, that's...
I think so, because it's got to be privileged, isn't it? Why is it not just very clearly privileged? It doesn't matter whether or not you use it for litigation.
Yeah.
It's got to fall under 119.
Yeah, provided they were properly provided. And what you said is absolutely critical, because it was in the case that I was involved in, it was done while the clients were still effectively running their own litigation and acting as their own lawyers. So there hadn't been the proper letter of instructions that had gone out with all of the you're bound by the code, etc. So the fear there was that the fact of Mr. X's involvement might not actually be covered. But in circumstances as one you've given me where they're instructed properly. Thank you all very much.